बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलाम वालेकुम। हाई कोर्ट रूल्स एंड ऑर्डर्स वॉल्यूम 3, वॉल्यूम 1 और वॉल्यूम 2 में कंप्लीट कर चुकी हूँ। वॉल्यूम 3 आज, और उसके बाद वॉल्यूम 4। ये सिर्फ ओवरव्यू करती हूँ मैं। जो मेरा कंप्लीट लेक्चर है, जो घंटे वाली वीडियोस आपको मेरी नज़र आएंगी ना किसी भी बुक के हवाले से, वो जस्ट ओवरव्यू है, सिर्फ उन लोगों के लिए जो कि फर्स्ट टाइम किसी बुक का पढ़ रहे हैं। क्योंकि बाद दफ़ा हमें बुक देखने में लगता है कि पता नहीं बहुत बड़ी बुक है, स्पेशली ला के, और इस वजह से हम नहीं पढ़ते हैं। जबकि अगर हम उसको पढ़ के देखें तो वो बहुत आसान होती है, और जितनी भी ज़्यादा लेंथी बुक्स हैं ना, वो उतनी ही उनकी लैंग्वेज आसान होती है। और इसलिए ओवरव्यू करूँगी सिर्फ, आपको वो देखने से ही, हेडिंग पढ़ने से ही काफ़ी सारी चीज़ें समझ आ जाती हैं। मज़ीद जब आप इसको पढ़ेंगे तो आपको मज़ीद क्लैरिफिकेशन हो जाएगी। उसके अलावा इसके अलग से मैं एक सीरीज़ स्टार्ट करूँगी, जो कि एक एक चैप्टर का डिटेल लेक्चर हो। चलें फ़िलहाल शुरू करते हैं। पहला चैप्टर इसका है जी, प्रैक्टिस इन द ट्रायल ऑफ क्रिमिनल केसेस। अच्छा, जुडिशियल एग्ज़ाम के हवाले से इसको आप क्रॉस रेफरेंस में देख सकते हैं। क्रिमिनल लॉ के पेपर में, ये बेसिकली क्रिमिनल पेपर के हवाले से है, और इसका क्रिमिनल लॉ का जो प्रैक्टिस है क्रिमिनल कोर्ट्स की, उसका चैप्टर 1 है। क्रिमिनल ट्रायल के हवाले से कोई भी क्वेश्चन आता है तो आप उसको चैप्टर 1 का क्रॉस रेफरेंस दे के लिख सकते हैं। मज़ीद इसके पार्ट्स हैं, अगर आपको पार्ट्स भी याद आ जाते हैं तो वेल एंड गुड, नहीं तो चैप्टर भी खाली काफ़ी होता है। अच्छा जी, आगे है कोर्ट आवर्स एंड प्लेसेस ऑफ सिटिंग। ये अगर आपने फैमिली सिविल कोर्ट वाला जो मेरा फर्स्ट लेक्चर है सिविल कोर्ट्स ऑर्डिनेंस वॉल्यूम 1 का, तो वो और ये दोनों मिलते जुलते हैं। दोनों में से एक भी अगर आप पढ़ लेंगे तो आपको दोनों की समझ आ जाएगी। इंस्टीट्यूशन ऑफ ऑर्डिनरी पेटिशंस, अर्जेंट पेटिशंस, और है जी कोर्ट हाउस इन एन ओपन कोर्ट, स्पीडी डिस्पोजल ऑफ केसेस, क्लोजिंग आवर ऑफ कोर्ट, एडजर्नमेंट्स कास्ड बाय हॉलीडेज। ये सारी चीज़ें हाई कोर्ट बताएगी, इसमें कुछ भी नहीं लिखा हुआ खास। डेली प्रोग्रेस रिपोर्ट्स, एक्सप्लेनेशन ऑफ डिले इन क्वार्टरली स्टेटमेंट्स, हिस्ट्री शीट्स। पार्ट बी है जी, इनिशिएशन ऑफ प्रोसीडिंग्स, राइट ऑफ अक्यूज्ड फॉर ट्रांसफर ऑफ अ केस टेकन अप बाय मजिस्ट्रेट ऑन इंफॉर्मेशन और नॉलेज, complaints how to be dealt with the oral examination of complaint and preliminary inquiry, importance of examination of complainant before issue of process, no preliminary examination of complaint necessary in police challenge, inquiry into nature of offence and other preliminaries in order to see whether court has jurisdiction. Jurisdiction also depends on the place of commission of offence. Cases where place of commission of offence is uncertain, procedure where magistrate thinks that he has no jurisdiction or cannot impose proper sentence. अच्छा जी, आगे है पार्ट सी, अटेंडेंस ऑफ अक्यूज्ड पर्सन्स, व्हेन समन्स और वारंट्स शुड इशू, डायरेक्शन ऑफ मजिस्ट्रेट टू इशू समन्स और वारंट्स शुड नॉट इशू अनलेस एब्सोल्युटली नेसेसरी, बेल, when attendance of accused may be dispensed with, service of process. Part C, attendance of prisoners in criminal courts, attendance of prisoners in criminal courts. Part D, procedure in inquiries and trials by magistrate, charge to be framed, conviction on admission of truth of accusation, statement made under section 164. Part E, record of evidence in criminal cases, only relevant evidence should be recorded. Duty of court to elucidate facts, mode of recording evidence, comparison of memorandum with vernacular statement, memorandum in English, statement of witness to be read over, evidence and judgment in summary trials, particulars of witness or parties to be noted. Examination in chief, illegible record, documents on record should be duly proved. Demeanor of witness record to contain a brief note of all material orders passed. Notes, order to be written by the magistrate in his own hand. Notification, re-court language. Part F, dismissal of cases in default. Reasons for dismissal in default should be recorded. Instruction to be observed in re-dismissal of complaints etc. by reason of the absence of the complainant. आगे है जी पार्ट जी, miscellaneous matters in connection with inquiries and trials. Age of accused persons, complainants and witnesses to be carefully considered when the point is material. 5 है जी, exhibits. Part H. The judgment. Contents of the judgment. Judgment should be dated, signed, and pronounced in the presence of accused. Judgments not written by magistrate. Criminal parts of the courts should be noted in the record of final order. The powers of various criminal courts, court of session, judicial magistrate, executive magistrate, special power to be noted in the record and final order. Separate judgments in rate cases, criticism on the conduct of police and other officers, award of cost, application of fine towards cost and compensation. Compensation not to be paid until appeal is decided. Award of compensation to acquittal of accused when offence is compounded. Compounding cases of grievous hurt should be discouraged. Points to be considered before a compromise is permitted. Chapter 2. Summary trials omitted. Chapter 3. Security cases. Important preliminaries. Preliminary inquiry. Contents of the order to proceed against security pending inquiry. Order to proceed to be communicated to accused. Form of process. Procedure for the commencement of trial. Proof required and exercise of direction with caution. Nature, amount, and period of security. Age of accused. Action to be taken when security is not necessary. Final order should state full particulars about bonds required. Joint trials and period of security. Bond should be single and no stamp is required. Commencement of period of security, suspension of order, and form of warrant when security is not furnished. Kind of imprisonment in default of security. Completion of record before consignment. Restriction order instead of security may be proper in certain cases. Chapter 4. Trial of riot cases. Careful handling required. Court's duty to ascertain the true version. Right of self-defense. Separate trials when both parties are prosecuted. Case of such each accused should be separately sifted. An unlawful assembly is its common object and use of violence must be proved. Joint liability of accused. Sentence when several offences are committed. अच्छा उसके बाद चैप्टर 5 omitted है. चैप्टर 6 ट्रायल ऑफ रियट केसेस. पार्ट ए जनरल. पीपीसी में इसका रेलेवेंट सेक्शन 146 है. 146 है या 148. केसेस अगेंस्ट पब्लिक सर्वेंट और लोकल बॉडीज शुड बी रिपोर्टेड टू डिस्ट्रिक्ट मजिस्ट्रेट. कॉपीज ऑफ to be supplied free to departmental officers. Criminal cases against police officers. District magistrates shall not ordinarily try cases against police officers. Criticism of conduct of police officers in judgments. Action to be taken on such criticism. अच्छा जी. पार्ट सी है क्रिमिनल केसेस ejecting military officers and soldiers. Cases to be tried only by district and first class magistrate. Copy of judgment to be sent to superior officer of accused. Military rank of accused to be stated in the warrant of committal to prison. Information of conviction to be sent to cantonment magistrate to superior officer. Information of conviction of prisoned officers. Information of conviction of army reservists. Rules for retrial of persons subject to military, naval or air force law. अच्छा जी. उसके बाद है आगे ड्यूल jurisdiction of court martial and civil court and the prescribed authority to decide by whom the case to be tried. Procedure in cases of civil offences. चैप्टर 7 भी omitted है इसका. अभी तक 3, 5 और 7 तीन omitted हो गए. Chapter 8 cases relating to offences affecting the administration of justice and contempt of court. Offences affecting the administration of justice. Complaint of offences mentioned in section 195 CRPC cannot be instituted by private individuals. Successor of an officer before whom offence was committed can lodge complaint. Main point to be considered by courts in initiating proceeding under section 476 CRPC. Procedure to be lodged without delay. Gross cases of false evidence should not be left over. Special care to be taken in recording evidence where a witness appears to be giving false evidence, contradictory statement and liability of being charged. Complaint can be lodged by the court or by appellate court. Deterrent sentence in case of perjury. Part B, contempt of court. Court can try of the offense itself or send the case to another court. Appeal from conviction. Cases tried by magistrate in court should be sent to session judge for examination. Contempt by ignorant people. When High Court may punish for the contempt of subordinate court. Chapter 9, Witnesses, Criminal Courts. Part A is committed. Part B, instructions for the guidance of the Nazarat and presiding officers in order to check fraud and embezzlement with respect to the district of the diet and road money of witnesses. Instruction for preventing the frauds in expenses of diet money and road money. Specimen signature to be kept. Comparison of specimen signature. Responsibility of Nazir or Naib Qasid not to make payments. Criminal Registered 18 Part 4 Volume 6B. Outlying courts. Security forum officials. Nazir should not keep money deposits. Inspection by Deputy Commissioner. Part C, commissions omitted. Part D, expert witness. Evidence of expert witness and instructions read the same. Evidence of the chief inspector of explosives. Evidence of chemical examiner in or his assistant. Firearms experts. Ballistics experts. Chapter 10, Bail and Recognizance. Principle governing grant of bail. Recognizance. Bail in non-bailable cases. Cash on or government promissory notes may be accepted in lieu of bail. Bail to be granted promptly. Release on bail by superior courts. Bail application on holidays. Disposal of bail application in the absence of session judge. Inquiry about sufficiency of bonds. Forfeiture of bail bonds. Form of bond for appearance before High Court. Form of bond and bail bond. Surety bond. Date of hearing to be communicated to the accused and sureties. Discretion of the High Court. Rearrest or on cancellation of bond. Bail application to be treated as urgent. Chapter 11, Investigation. Relation between police and magistrate. Police can investigate suo motu only cognizable cases. Police to record information in non-cognizable cases also. Procedure of police on receipt of information. Daily station diary. Action to be taken when station police officer decides not to investigate cases. Distinction between recording of reports under section 154 and 157 of the Code of Criminal Procedure. Procedure to be adopted by magistrate when offender is not known to the complainant. Procedure of police when there is or is not sufficient evidence against the accused. Police cannot detain in custody an accused for more than 24 hours without orders of magistrate. Police remands. Procedure of magistrate granting remand. Arrest by police to be reported when police may discharge persons once arrested. Control of magistrate over arrest by the police. Police diary to be kept and sent up regularly. Duty magistrate to supervise police investigation. Magistrate must have among his own records the means to supply statistical information. Police to send to the magistrate copies of records made under section 165 CRPC. Power of police to summon witness and to arrest offenders. Part B, remands to police custody. Introductory. Distinction between remand to police custody and remand to judicial lockup. Non-completion of police investigation does not justify detention by police. Remand to be granted in cases of real necessity. Magistrate should discourage tendency of police to take remand to extort confession. Remand cannot be granted for more than 15 days. Procedure when accused is brought before a magistrate to obtain remand. As accused must be produced before the magistrate, who should satisfy himself about necessity for remand. Principle applying remand cases. Reasons for grant of remand to be recorded and copies sent to session judge. Procedure when a remand for more than 15 days is required for completion of the case. 11. Strict supervision to be exercised over the action of magistrate granting remands. Instructions issued by the provincial government in respect to remands. Right of accused to access to counsel and friends. Part C, Identification Parade. Instructions issued by the Punjab government regarding identification parades. List of all persons included in the parade should be prepared. Note about identification by witness, objection or statement by accused or identification witness to be recorded, and power of magistrate to decide objections. Duty of magistrate to record precautions taken and to note other points. आइडेंटिफिकेशन परेड का फॉर्म प्रोसीडिंग ऑफ द मजिस्ट्रेट। अच्छा जी, उसके बाद है पार्ट डी, कैंसिलेशन ऑफ केस रिपोर्टेड बाय पुलिस। मजिस्ट्रेट्स पावर टू कैंसिल केसेस रिपोर्टेड बाय पुलिस। ड्यूटी ऑफ मजिस्ट्रेट टू सेटिस्फाई हिमसेल्फ बिफोर पासिंग ऑर्डर। मजिस्ट्रेट डीलिंग विद द फाइनल पुलिस रिपोर्ट इज competent to pass order. Order of cancellation when to be passed and by whom. Part E, custody of property sent in by the police. Kinds of property sent in by police. Custody and disposal of the property. Custody and disposal of the property. Custody and disposal of the property. Custody of coins, currency notes, etc. Responsibility of police for safe custody. See also volume 4 chapter 10. Inspection by police officer of record and others affecting the working of the police. Inspection by police officer of the record of criminal cases in which a member of the police is convicted or left under suspicion. Copies of certain confession to be sent to Inspector General of Police. All modifications of the order of the lower court made in appeal. Revision or reference should be communicated to the Superintendent Police. आगे इसके ये फॉर्म वो आ गए हैं सेक्शन पीपीसी के चैप्टर 4 चैप्टर 7, मतलब इन मामलों में फॉर्म्स पुलिस ने अरेंज करने। पार्ट एच, मिसलेनियस केसेस अगेंस्ट पुलिस ऑफिसर। पुलिस रिपोर्ट टू सेंड टू मजिस्ट्रेट थ्रू अ सुपीरियर पुलिस ऑफिसर। और है जी कॉपी ऑफ जजमेंट क्रिटिसाइजिंग कंडक्ट ऑफ पुलिस टू सेंड टू हायर अथॉरिटीज। चैप्टर 12। चैप्टर 11 में आइडेंटिफिकेशन पीरियड है, आपने याद रखना, रेफरेंस में लिखेंगे तो बेस्ट रहेगा। पुलिस डायरीज एंड स्टेटमेंट्स बिफोर द पुलिस व्हेन अक्यूज्ड। ये 11 और 12 पुलिस से रिलेटेड है। व्हेन अक्यूज्ड इज इंटाइटल्ड टू सी पुलिस डायरीज और स्टेटमेंट ऑफ अ विटनेस रिकॉर्डेड बाय पुलिस। इंस्ट्रक्शन रिगार्डिंग डिस्पैच ऑफ पुलिस डायरीज एंड their translation with the records of criminal cases to the High Court. Use of police diary by court. Use of statement of witness made before police when accused may get its copies. Method of contradicting a witness with previous statement. Use of first information report for the purpose of corroboration of statement. Confession made by accused to police is admissible in evidence if it has led to discovery of any fact. Dying declaration excluded from operation of section 162 CRPC. पढ़ लेते हैं इसको थोड़ा सा, क्या कहते हैं। डाइंग डिक्लेरेशन फॉलिंग अंडर आर्टिकल 46(1) ऑफ कानून शहादत आर एक्सक्लूडेड फ्रॉम द स्कोप ऑफ 162 ऑफ द कोड ऑफ क्रिमिनल प्रोसीजर। Chapter 13, confession and statement of accused person. Statement of accused at various stages explained. Use of confession of accused during police trial recorded by magistrate. Presumption attached to confession recorded by magistrate and its evidential value. Safeguards provided in law to obtain a voluntary and precisely recorded confession. Important features of section 164 criminal procedure. Form prescribed for recording evidence. अच्छा जी, उसके बाद instructions for recording confessions. Accused who has made a confession should not be kept in police custody but should be kept in judicial lockup separate from other prisoners. Accused can be examined to explain the prosecution evidence against him and not to fill up gaps in the evidence. Written statement of accused. Mode of recording examination of accused. When evidence may be led to prove that accused duly made the confession or statement. Instruction about recording confession. अच्छा जी, उसके बाद है चैप्टर 14 अप्रूवर्स डेफिनेशन। ये अकम्प्लिस जिसे हम कहते हैं। व्हेन पार्डन में बी टेंडर्ड बाय एंड बाय होम। मजिस्ट्रेट करेगा टेंडर। Reasons for tendering pardon should be recorded and extent of a pardon explained in the to the intended approver. If approver gives false evidence, he can be tried for the offence and also for perjury. Approver should be kept in judicial custody until close of trial. चैप्टर 15 है जी प्रोसीडिंग अगेंस्ट absconders and record of evidence in their absence measures to enforce appearance attachment and sale of property proclamation consequences of non appearance of proclaimed section sale of property directions for sale only life interest can be sold in certain cases property or its proceeds may be given to absconder if he appears before the court. Record of evidence in the absence of the accused. Introductory evidence recorded in the absence of the absconded accused may be used against him in certain cases. ये trial and absentia जो होता है. Proceedings under section 512. Medical evidence should be recorded in some cases. Section 512 can be availed of also in cases when offence is not known. Confession by accused implicating as absconder cannot be used after the execution of the confession case. चैप्टर 16 चैप्टर 15 में ट्रायल एंड ऑप्शंस है चैप्टर 16 है जी एक्स्ट्राडिशन एंड फॉरेन jurisdiction क्रिमिनल कोर्ट्स पार्ट डी एक्स्ट्राडिशन फ्रॉम पाकिस्तान लॉज एप्लीकेबल प्रोसीजर ऑफ सरेंडर एंड फॉजिटिव टू फॉरेन स्टेट्स अरेस्ट एंड डिटेंशन ऑफ फॉजिटिव क्रिमिनल ऑफ फॉरेन स्टेट्स अच्छा जी बस उसके बाद एक्स्ट्राडिशन ब्रिटिश इंडिया में शुक्र है कुछ तो ओमिट किया इंडिया वाले पार्ट सी jurisdiction of criminal courts in regard to offences committed outside Pakistan liable to be tried liability of citizen of Pakistan trial permissible only on the certificate of political agent or section of government even inquiry not permissible without certificate court to record a final finding about nationality of offender and insert in charge special rule of evidence part D miscellaneous power of police to arrest without warrant chapter 17 है जी lunatics classification lunatics may be classed as follows criminal lunatics whose detention in asylum or lunatics so found by inquisition criminal lunatics report orders lunatics so found by inquisition term mental sent for and mental patient and mental hospital explained the admission in the Punjab mental hospital further directions about admission criminal lunatic inquiry magistrate bound to make inquiry about unsoundness of mind of the accused stay of proceeding if unsoundness of mind proved trial of the fact of insanity in sessions trials accused may be released on security in releasing accused due regard should be paid to public safety action to be taken when accused cannot be released on bail accused may be sent to medical hospital in such cases proceedings under section 464 can be taken only when a prima facie case is made out by prosecution evidence a resumption of proceeding under section 467 patients certified by mental hospital to be fit to make their defense orders of magistrate for detention may be varied by government procedure when the accused is of sound mind at the time of trial but was not at the time of committing the offense did to if accused is acquitted on the pleas of insanity he be released 16 superintendent jail to keep the prisoner under observation and to report the result thereof criminal lunatic detention medical history sheet to be sent to government same should be sent to mental hospital a memo of principle to be observed in dealing with the cases of criminal lunatics crime offences against the prison intoxicating drugs type acute or chronic mania crime offences against the person cause other than intoxicating drugs types acute or chronic mania crime not an offense against the person but where mental attitude is aggressive type acute or chronic mania crime not an offense against the person so or if so trivial in its nature mental attitude not aggressive crime murder type melancholia crime attempted suicide type melancholia अच्छा ये जो crime non criminal lunatic reception order when passed who may pass reception orders on petition reception orders petition otherwise period of detention for medical examination copy of reception order to be sent to mental hospital question to be put to medical witness in case of suspected insanity inquiry as to the domicile of the lunatic admission of a lunatic in mental hospital in another province action to be taken on subsequent discovery of the domicile of the lunatic in another province Documents to be sent when lunatic is to be admitted to mental hospital. अच्छा जी, recovery of maintenance charges of patients admitted in the Punjab mental hospital omitted. Chapter 18 है जी medical legal work. Part A postmortem examination, effect of decomposition. Duty of medical officer to conduct postmortem examination when nothing is known about case causes. Examination of body when admissible for examination. Rules about the deposition of medical witness and reports of chemical examiners. References to the chemical examiner, medical officer to be consulted about articles to be sent to chemical examiner. In certain cases, police may send articles direct. Statement to accompany articles sent. Mode of packing of articles to be sent. Weight of articles and to be noted. Precautions in packing bottles. Articles to be packed and sealed in the presence of forwarding officer. Invoices of articles in and postmortem report or statement to accompany articles. Evidence should be taken to prove that chemical examiner report refers to the subject connected with the inquiry. Identity of body to be proved. Proper custody of articles to be proved. Evidence of non-professional witnesses or blood and human hair should be accepted with caution. Rules for the guidance of police officer regarding the submission of blood stain cases to the seriologist. The government of Pakistan Islamabad seriologist appointed to distinguish human blood from the other blood. Articles to be sent to chemical examiner when seriologist. पार्ट ए जनरल ओमिटेड है. उसके बाद चैप्टर 19 सेंटेंसेस. पार्ट ए जनरल. द अवार्ड ऑफ सूटेबल sentences depends on a variety of considerations. Various kinds of punishment, minimum and enhanced punishment prescribed in different cases. Limits of sentences which different classes of magistrate can impose. Procedure when magistrate thinks that the accused should receive greater punishment than he can award. Limitation imposed by Section 71 Pakistan Penal Code and Section 35 Criminal Procedure Code. Sentences in case of accused convicted of several offences. Concurrent sentences. Recommendation to government for remission or commutation of punishment. Part 9 B. Fine. Fine should be in proportion of the means of the offender. Part C. Imprisonment. Kinds of imprisonment and their selection. When simple imprisonment is suitable, when solitary confinement is suitable, when whipping. Cases in which whipping not permissible. Part E. Detention of in a reformatory school omitted. चलिए आगे भी सारा omitted है. Part H. Death sentences. Reasons for awarding a lesser sentence should be recorded when the offence is punishable with death. Instruction to be observed by courts passing death sentence. Chapter 20 Execution of sentence. Fines. Warrants for execution. Signature by means of stamp not permissible. Warrants should be signed, sealed, and in the prescribed form. Separate warrants for each person. Superintendent of jail should not refuse to admit a prisoner owing to defect in the warrant. Leaper convict to be sent to Mianwali jail. Class of prisoner when other than C to be noted in the warrant. Warrants for release of remission of sentence. Rules about classification and treatment of conviction and under trial prisoners. Chapter 9 Classes of prisoner. Rules 224. Classification of convicted persons, casuals and habitual. Classification of convicted persons according to age. Nature of sentence. Classification of under trial proceeding. Classification of women prisoners. Separation of prisoners. Further provision regarding separation. अच्छा जी, उसके बाद है exception to the rule regarding separation, association and segregation of prisoners, segregation of under trial prisoners, occupation of vacant cells, separation of habitual prisoners, separation of casuals, procedure when separation by day is not feasible, separation of prisoner to prevent the commission of any offence, separation to be as complete as possible. Rules for the classification of prisoner into A, B and C class. Classifying authority. Superintendent may award B class to convict prisoner. Qualifications for A and B disagreement between the convicting court and the district magistrate. Condemned prisoner governed by the rules classification of under trial prisoners. Whipping mode of infliction. Flogging should be inflicted in private in the presence of a medical officer. A thin cloth to be spread over the buttocks. Magistrate to certify that the prisoner is in a fit state of health, not to be inflicted until lapse of 15 days or until sentence is confirmed on appeal. Filing of appeal should be notified to the jail superintendent. Explanation. Jail superintendent may wait for such further time as is necessary for communication from the appellate court. Session judge to decide for what further time the jail superintendent should wait. Copy of order for of whipping be given to accused. Magistrate should ensure that sentence has been duly carried out. Part D omitted. Part E sentence of death. Order of High Court to be sent to session judge for carrying out sentences. Execution of the orders of criminal appellate courts and courts of revision. High Court will certify its decision to lower court. Lower court will inform prisoner and the jail superintendent. Session judge will at once inform jail superintendent direct about all orders of release or alteration or enhancement of sentence passed by him. Prisoner not to be transferred from the jail until decision of appeal. Exceptions. Duty of jail superintendent to inform the superintendent of the jail to which the prisoner has been transferred about the orders passed by appellate court. Execution of sentence passed under section 35 criminal procedure code if the sentence which is to take effect first is set aside on appeal. The appellate court should direct the original court to issue a fresh warrant directing that the second sentence be carried out at once. Procedure for execution of order of appellate court when accused has been admitted to bail. Procedure when accused surrenders to his bail in appellate court. Procedure when retrial is ordered. Form of warrant when a sentence is modified on altered or appeal. Chapter 21 first offenders omitted. Chapter 22 youthful offenders. ये जेवनाइल जस्टिस सिस्टम एक्ट है, अगर उसका क्रिमिनल लॉ के पेपर में क्वेश्चन आता है कोई भी तो आप उसमें चैप्टर 22 का रेफरेंस दे सकते हैं. कमिटमेंट टू प्रिजन ऑफ चिल्ड्रन शुड बी अवॉइडेड. रिमांड ऑफ प्रिजन to prison pending inquiry or trial not desirable. Police not empowered to release children on bail, but it should produce them at once before nearest magistrate for grant of bail. Sentence against juvenile offenders, alternative imprisonment and detention in reformatory school to be avoided. Cases should be sent to courts exercising powers of whipping, while sentenced to but unfit for whipping to be sent to reformatory schools. Age of the offender to be noted in the judgment. Sentence of youthful offenders. Age of the offender to be noted in the judgment. Sentence of youthful offenders to imprisonment to be reported to district magistrate. Monthly return of offenders under 24 years of age to be sent duty of the district magistrate. A short sentence to be avoided. Children's court. Selection of magistrate to try children cases. Trial to be held at a different place. Simple language of trial. Outsiders should not be allowed at the trial. Reformatory schools. Courts empowered to direct youthful offenders to the reformatory school. Procedure for a magistrate not so empowered. Recording a finding as to age. Definition of youthful offenders. Rules framed by government. Youthful offenders to be sent to the reformatory school when magistrate awards imprisonment for life. Offences specified. Reformatory school intended for casual criminals and first offenders capable of information disqualifications preventing admission. Period for which detention in the school is to be ordered. Session judge should recommend to government when he thinks that youthful offender, though not admissible under the rules, is a proper person for admission. Classification of boys in the school. Court should recommend the class. Duty of court to inquire about accommodation in school and to make arrangement if there is no accommodation. Magistrate advised to visit the school. Sanctioning authority for travelling allowance for the visit. Second and third class magistrate not required to visit. Session judge may permit civil judges exercising criminal power to visit the school. Borstal jail, intended for the adolescent convicts of habitual type sentence suitable for different kinds of youthful offenders. अच्छा जी, उसके बाद है प्राइमरी ऑब्जेक्ट ऑफ कीपिंग सच ऑफेंडर्स इन बोस्टल जेल. When offenders should be sent to the Boston institution and went to the reformatory school. Chapter 23, Habitual Offenders, Preventive Measures. Preventive measure against habitual offenders. Sentences, enhanced punishment under Section 75 Pakistan Penal Code. Procedure of magistrate not competent to award enhanced punishment. Procedure when magistrate cannot punish adequately. Enhanced punishment not obligatory. Enhanced punishment not suitable in petty cases or in cases of old convictions. Case of organized crimes. Enhanced punishment suitable when previous conviction indicate a criminal habit which needs to be checked by deterrent punishment. Previous conviction for attempts to commit an offence not covered by Section 75 of Pakistan Penal Code. 8. Action to be taken by magistrate of second or third class when he cannot award adequate punishment. Duty of the police to prove previous conviction. Discovery of previous conviction after judgment has been pronounced. Previous conviction to be noted on the warrant of commitment and in a separate statement. Not on the warrant when the identity of the prisoner has not been proved or he declines to give account of himself. Definition and classification of habitual criminals. Persons liable to be classified as habitual criminals. Classifying authority, right of prisoner for revision of the order of classification, power of district magistrate on convicting court not to classify certain convicts as habitual criminal, revision of classification, habitual criminal to be kept in hospital in special jail, member of criminal tribe defined, convicting officer to decide about classification and should note it on the warrant, statement of previous conviction should be attached to. Residents of release convicts a copy of the order under Section 565 Criminal Procedure Code to be sent in jail. Notification. Released convict to notify at the time of release intended place of residence to release officer. Released convict to notify intention of to change his place of residence from the place which he specifies at the time of his release as the place at which he intended to reside. Released convict to similarly notify all subsequent intention to change residence. Period to be appointed for taking up residence in default of the convict to notify his actual residence. Released convict to notify the fact of his having actually taken up his residence at the place specified under pending rules. Particulars of place of residence to be supplied. Manner of notifying changes of residence. Identification of reconvicted persons. Introductory descriptive role of the convict. Charge sheet to be sent up by police. Charges to be sent to jail. Rules frame under the provisions of restrictions of habitual offenders. Definition: arrest of restrictions. Absence without leave. Passes. Times of report. Places of report. Mode of report. Leave for 1 day. Leave not exceeding 15 days. Long leave conditions attaching to absence on leave reports while on leave. Surrender of passes. Form of passes. Person on leave unable to return. Withdrawal of passes. Withdrawal of passes. अच्छा जी, उसके बाद है इसमें चैप्टर 24 सेशन केसेस जनरल. कॉग्निजेंस ऑफ कोर्ट ऑफेंसेस बाय कोर्ट ऑफ सेशन मजिस्ट्रेट टू सेंड द केसेस टू कोर्ट ऑफ सेशन मजिस्ट्रेट टू अप्लाई हिज माइंड बिफोर सेंडिंग द केस मजिस्ट्रेट टू जस्टिफाई सेंडिंग ऑफ केस स्टेट ऑफ प्रोसिक्यूटर ट्रायल बाय एडिशनल सेशन जज. Trial of session cases. Introductory reservation of several days for possible session cases. Priority of session cases over the work. Prompt disposal of session cases. Examination of record. Session judge may summon any witness not included in the calendar charge to be read out. Mode of recording evidence. Papers to be transferred to session record. Medical evidence. Inquest report. Other circumstances to be proved. Identity of body and clothes. Custody of other articles. Every article to be produced. Plans. Exhibits. Use of previous statement of witness. Procedure. Public prosecution procedure in case of previous conviction. Judgment should be pronounced in open court by session judge. Judgment to be written before announcing. Copy to be forwarded to the district magistrate. Documents to be forwarded to the High Court when sentence requires confirmation. Reference to High Court shall be in prescribed form. Then sentence should be accused shall be informed about period of appeal. Session judge to ask accused and promptly deliver if he requires a copy of judgment endorsement on copy sent to accused. Record to be sent to High Court soon after period of appeal has expired. Notice to accused and Advocate General on receipt of record. Copy of High Court judgment to be sent to session judge. Record to be sent to government when death sentence has been confirmed. Death for execution of death sentence. Record to be sent to government when a woman has sentenced to imprisonment for infanticide. Weapons to be sent to the High Court. Blood-stained cloth sent to High Court. Exhibited articles. Providing an accused person when with the legal advice. Presiding officer to report whether accused can afford to engage counsel. Counsel for accused to be provided by session judge. Fees of counsel. Chapter 25 Appeal and Revision Criminal. Admission of petition. Chapter 25 Appeal and Revision. Persons competent to lodge petition. Authentication of petitioner. Written by jail officers for prisoner. Petition received by post. Pleader engaged by agent. Court fees on appeal. Appendixes. Procedure in hearing criminal appeals. Introductory summary. Disposable appellant to be here. Notice of date of hearing. The order fixing the date should state under what section the hearing is. Appeal should not be dismissed in default. If appeal cannot be rejected summarily, it should be admitted to hearing. Contents of judgment. Remand. Notice of appeal in railway cases. Notice to district magistrate and railway authority. अच्छा जी आगे चलते हैं. Appeals from orders of acquittal. Appeal to be filed in certain cases. Travelling expenses for the accused. Legal assistance in cases of enhancement of sentence. High Court can alter the conviction from section 304 to 302 only when government appeals. Requisition for records for security. When appeal for acquittal is contemplated. For securing the original records of trial court. For scrutiny in cases where appeals in scrutiny cases omitted. Supply of copies to appellants and applicants for revision and transmission of appeals and applications of prisoners to appellate and revisional courts. Appeal to be accompanied a copy of judgment or order. Fee. Supply of copy in certain cases. Application for revision to be accompanied by copy of judgment. Free supply of copy to accused in warrant cases. Free supply of copies to jail prisoner. Petition of appeal preferred by prisoner. And typewritten copies of record and judgment to be sent to High Court. Extra copies to be prepared in advance by stenographer. Chapter 26 Transfer of criminal cases. Transfer of criminal cases. Power of High Court to retransfer of cases. Session judge power transfer cases. And cases triable in more than one district forum to be determined with regard to public convenience. 197-183 CPC. Procedure when a magistrate thinks the case should be tried in another district. Reasons to be given for proposal transfer. Common grounds on which application for transfer are made. Remarks on those grounds. Cases of local bodies with which magistrate is concerned. 556. Connection of the magistrate with the party. Cases in which magistrate has already expressed his opinion. Cases where in a party apprehends that he will not have a fair trial. Adjournment on application under section 526. Transfer application should be supported by affidavit. Notice to other party. High Court will not entertain application unless session judge has first been moved. Application for transfer of criminal cases to form a part of separate record. Chapter 27 Judicial lockups. General remarks. Difference between a judicial and police lockup. Persons to be kept in judicial lockup whether other lockups are arbitrated, judicial lockups, management of police lockups, and their use as judicial lockup. Certain lockups are declared to be subsidiary jails. Financial control of Inspector General of Prisoner over jail lockups. Inspection of judicial lockups by session judge. Responsibility of district magistrate for efficient management. Quick disposal of the prisoner to the lockup. Of the lockup. Interview with the prisoner in lockups. Harassing of prisoner in lockup. Rules regulating the management of and control over judicial lockups and the treatment of under trial prisoner. Control, management, and inspection of judicial lockups in jail. Control over other lockups. Officers in charge of judicial lockups. Responsibility of police to guard lockups and to conduct prisoner. Count of prisoner to be taken morning and evening. Officer in charge responsible for discipline and proper dieting of prisoners. Prisoners tickets. Date of hearing to be entered in the warrant. Weekly reminder in case in which prisoner has been in lockup for more than a month. Monthly return. Inspection by Inspector General of Prison. Inspection by Session Judge, Subdivisional Cantonment Magistrate to see the sanction discipline of lockup under the control. Separate accommodation for female and juvenile prisoner received of prisoner taken out. Police to conduct prisoner not to be kept in police lockup without orders of magistrate. Prisoner accompanying magistrate on tour should be taken to judicial lockup. Provision of the lockup in each courthouse. Prisoner should received or taken out under the orders of magistrate. Expenses of transfer of prisoner. Sick prisoner to be kept in jail hospitals. Transfer of sick prisoners. Clothing, handcuff, fetters, and other restrained habitual offenders and previous convicts to be reported. Information to be sent to officer in charge when a prisoner is discharged or released on bail. Interviews and correspondence. Disposal of money or other property found on the prison of the prisoner. Punishment for breach of discipline. Prisoner under sentence temporarily confined in lockup. Register of under trial prisoners. Chapter 28 omitted. Chapter 29 Public Prosecutors. Appointment of Public Prosecutors. Appointment, transfer, etc. Supply of copies to the Advocate General and Public Prosecutor. Records and copies to be supplied in cases before subordinate courts. Records and copies to be supplied in cases before subordinate courts. Copies in case of before High Court. Judicial power, criminal powers or criminal courts. Power defined in Criminal Procedure Code and the Acts of Special Powers. Powers conferred by government. अच्छा जी conferment of criminal powers. Magisterial power. Instruction and recommendation for conferment of criminal magisterial power. For federal and provincial civil servants, channel of recommendation when commissioner shall consult session judge. Statement of powers. Exercise of powers to be sent along with recommendation. Necessary qualification for exercise of special powers. Recommendation should ordinarily be made at the time of revision and annual confidential powers list. Conferment of higher powers in emergency does not qualify permanently. Chapter 31 omitted. और ये कंप्लीट हो गया वॉल्यूम 3 हाई कोर्ट रूल एंड ऑर्डर का. थैंक यू फॉर लिसनिंग. अल्लाह हाफिज़.